Okay, we are going live. And we are all set. Excellent. Okay. And some people will hop on with us. I'm going to go ahead and get started. Good morning, everybody. Thank you for joining us today. My name is Jamie Chavez. I'm the president and CEO of the Westminster Chamber of Commerce. And every Monday, we bring you a special broadcast, usually featuring city folks, Mayor Pro Tem, city councilors, and other city leaders. We do have a special guest today, so we're excited for that. If you're new to the broadcast, thank you for being here. We appreciate you joining us this morning. I encourage you to like our Facebook page and follow us so that you will receive notifications for when we go live in the future. And then we also do broadcasts every Wednesday that are dedicated to introducing you to our latest chamber members and letting you know what their businesses and organizations bring to the community. So we hope you join us for those as well. We also reserve one Friday of the month for county updates, and we will interview Jefferson County Commissioner Rachel Zenzinger. We're also going to be adding Adams County Commissioner Steve Odorizio to those, so hope that you will tune into those as well for Brody County matters. As you watch the broadcast this morning, we encourage you to engage with us. Go ahead and drop any comments or questions that you have, and we will get those answered during the interview. And now finally, a warm welcome to Mark Hillman, the Executive Director from the Colorado Civil Justice League. How are you today?
I'm well, Jamie. Thank you.
Yeah, thanks for joining us. We will start with just kind of an introduction to yourself and to the organization, and then we can get into it.
Sure. Well, I am the Executive Director of Colorado Civil Justice League. I actually served in the legislature many years ago. I was elected to the Senate in 1998 and served through 2005. And then I served parts of 2005 and 2006 as state treasurer. About a year or so after that, I joined the board of Colorado Civil Justice League. And in 2009, was asked to step up and be the executive director of CCJL. And I've been doing that ever since. I've seen us do some really good things. I've seen us try to stop some really bad things, sometimes with good results, sometimes without quite as much success as we would like to have had. But every year and every legislative session presents a new puzzle, and we're happy to do the best to try to keep litigation as infrequent as possible for Colorado businesses.
Awesome. Well, so maybe start by telling us what exactly the Colorado Civil Justice League does, your mission, and to promote common sense in the courtroom. Maybe just Tell us a little bit about that.
We are the only organization in Colorado that is focused exclusively on limiting unreasonable lawsuits. We're a nonpartisan organization. We have members that are in manufacturing, automotive, energy, healthcare, insurance, construction, entertainment, finance, legal, and very importantly, in small business. And as you mentioned, our hallmark is common sense in the courtroom. And to us, that means justice for those who have been injured by the wrongdoing of someone else, balanced by fairness for defendants who have done nothing wrong. Because if you live in Colorado today, you probably know that just because you have done something wrong does not mean you won't be sued.
Right. So I guess that leads to the next question. Why is tort reform such an important issue for Colorado's business and legal landscape right now?
Well, Colorado's had a good history as a leader in tort reform from the 1980s all the way through the early 2000s. The business community in Colorado worked with state lawmakers to create one of the nation's best systems of civil justice through tort reform legislation that preserved common sense and due process. Tort law, for those of you who may wonder what that is, tort law gives someone who has suffered an injury the right to recover monetary damages if that injury was caused by someone else's wrongful act or negligence. And the function of tort law is not to punish the person who caused the injury, but it is to provide the injured party with a remedy to make them whole. An efficient tort system works well because it draws a bright line, and that bright line is good for business because it deters unsafe practices and unsafe products, and it also provides fair compensation for true victims.
Great. So what's changed over the past decade to kind of shift the reputation in Colorado from being once known as a leader in legal reform?
Yeah, well, let me back up and tell you a few of the things that made us a leader. About 20 years ago, Colorado passed a series of laws that, to begin with, enacted one of the nation's strongest product liability laws. For example, it said that if you go buy a product from your local hardware store, take it home and use it in a way that it was never intended, and as a result of that, you're hurt or something you own is damaged, you can't turn around and sue the store or the manufacturer of the product for selling you a faulty product because you used it in a way that it was never intended.
Right.
And that bill was quite the dogfight to pass, but it passed and it served Colorado well, and it's still in place. Back at that time, the legislature also restored non-economic damage caps in medical malpractice lawsuits. Now, that's a lot of words, but if you are a victim of medical malpractice, under Colorado law, you can recover all of your actual documented expenses, lost wages, both backwards and forwards, all of your medical expenses, your rehabilitation expenses, expenses for perhaps modifications to your home that you may have to make because of whatever the injury was that was suffered from medical malpractice. The only thing there's a cap on is called non-economic damages. And these are damages for things like emotional stress, pain and suffering, inconvenience. They're damages that we know exist, but unlike the others, we can't pencil them out because, how many units of emotional stress did you suffer? And so two juries on two different cases or two juries on two different days hearing the same case might come up with vastly different amounts. And so because the state has an interest both in making certain that victims are compensated, but also that doctors and hospitals can continue to afford malpractice insurance, and so we can continue to have affordable health care for all of this, Colorado put a cap on how much could be recovered for those intangible non-economic damages. Colorado also established sensible remedies to home construction disputes, and those remedies made litigation a last resort. That's one of the elements here that didn't survive, unfortunately. Colorado also enacted an appeals bond cap of $25 million. An appeals bond cap is important because if you happen to be defending yourself against a lawsuit and the jury comes down with a $100 million verdict against you, and you believe the jury was wrong and that you can convince an appeals court that they were wrong, you may have to post a bond equal to the $100 million that jury came up with, because the law doesn't simply want you to spend out all your money on appeals and then not be able to pay the victim if the victim was indeed right. Colorado put a $25 million cap that says you can be forced to post a bond, but we're going to cap it at $25 million so we don't tie up all of the capital that a business may have or make it simply impossible to appeal. And we also limited the ability of the Attorney General to hire what I call bounty hunter private attorneys to represent the state of Colorado on a contingency fee basis. So if you think back to things like the tobacco lawsuits from 30 years ago, 20 years ago, in which private attorneys all around the country were hired by different states, and Colorado was the only state that did not hire private attorneys to do this. At that time, Attorney General Gail Norton did all of the tobacco litigation in-house with her own attorneys. But in the other states that participated in the tobacco litigation, they hired private attorneys, many of them representing several different states, who simply filed cookie-cutter lawsuits against the tobacco companies. And they all worked on a contingency fee, which means if they won the case, they got anywhere from 1/8 to 1/3 of the money that was awarded to the state. And if you were representing several of those states, we're talking about billions of dollars being paid to the state, and the law firm was entitled to get up 1/8 to 1/3 of that amount. So we put limitations in place that said we shouldn't do that, because when a private attorney is suing on behalf of the state, obviously their personal financial interest is very important to them, and understandably so. That may not be what's most important to the people of the state of Colorado. An injunction against unlawful practices or practices that they didn't believe were unlawful may be far more important. So we passed that law so that if they need to go out and hire an attorney, they can, but they have to document their hours. There's $1,000 an hour cap on how much the attorney can be paid. And back in the day when we used to explain that inside the Capitol, people would think $1,000 an hour, that's not nearly enough. And outside the Capitol, people would say, good grief, is that a cap at all?
Yeah.
So the good news is most of those provisions remain in place. And because of those, Colorado routinely ranked among the 10 best states in the U.S. Chamber of Commerce lawsuit climate survey. As recently as 2010, we were in the 10 best states. But in recent years, our lawsuit climate has taken a turn for the worst, dropping out of the top 10 and dropping as low as 35th in this particular study. And not surprisingly, as plaintiffs' attorneys have gained more political clout at the state capitol, they have also worked relentlessly to erode many of those foundations. And so advocates for common sense are playing a lot of defense these days. And more recently, Colorado has become a leader in national rankings, but for the wrong reasons. For example, in the past 3 years, legislators have introduced more than 100 bills that create new causes for lawsuits. They seem to have this notion that filing a lawsuit should be the way to resolve every problem. This amounts to basically what Bill Clinton back in the day called regulation through litigation, which means instead of simply passing a regulation and relying on an executive branch agency to enforce it, the bills that are passed create new laws that enforce regulation through what's called a private right of action, which means a private citizen can bring a lawsuit in court to enforce the law. Or sometimes these bills will create a new deceptive trade practice, which is a term which is designed to define a fraudulent act in the Colorado Consumer Protection Act. That means that more of our laws are not enforced by those executive branch agencies that have experience in handling a specific type of complaint. And even though we might not like the decisions that they make, there's at least a consistency you can see. So if you have to defend yourself in front of one of those agencies, you know what to expect. And instead, enforcement lawsuits are heard in a court of law by a judge who hears everything from murder cases to contract disputes to divorce cases to estate cases. And business owners are the most frequent targets of these private lawsuits, which are usually added to bills that create new forms of illegal workplace discrimination or unpaid wage complaints by employees or disability access claims. And these lawsuits sometimes can be a racket for plaintiffs' attorneys because just defending them before they ever go to court can often cost a business $25,000 to $50,000. And if they do go to court, it might cost $100,000 or more. And plaintiffs' attorneys understand very well these costs, and they know the business does as well. Plus, all of the inherent workplace disruptions that are caused by preparing to defend a lawsuit. So a common tactic is to offer to settle these lawsuits early. And employers usually look at that in one of two ways. Either they simply calculate the uncertainty of the outcome and the cost and all the internal disruptions at their business. And if they think that's greater than the cost of simply reaching a quick settlement, they may agree to settle. On the other hand, some businesses believe that if they have done absolutely nothing wrong, that settling simply puts a target on their back, and it's more likely to mean that they're going to be sued again in the future. And neither of those decisions is the wrong one. It just depends on the situation that a particular business happens to be in. And incidentally, when the legislature creates one of these private lawsuit provisions, it almost always includes what's called one-way fee shifting. So most people have heard of loser pays, which means that in certain cases, the winner of a lawsuit gets not only the damages, but their legal expenses paid by the loser. That doesn't happen in Colorado, but in these particular cases, one-way fee shifting means if the plaintiff wins, the defendant has to pay damages plus attorney's fees, plus, of course, their own attorney's fees. But almost never do these laws include any kind of a disincentive against filing dubious lawsuits. And so as a result of all of those things, two different economic analyses in the last 3 years have said that the cost of tort lawsuits in Colorado has created a hidden tort tax that is among the 10 worst in the nation.
So other than these, extreme costs that are being inflicted on business owners, what are some other real world impacts of Colorado being ranked among the top states for the highest tort costs per household, maybe even affecting average residents?
Sure. Well, the first thing to remember is that the cost of a lawsuit is always passed along to consumers, because just like a business has to pass along its production costs and its employment costs and everything else, it has to add it to the price of whatever it's selling and make sure that in order to make ends meet. So the real world impact of having this hidden tort tax are that it makes the cost of everything we buy more expensive, because it increases risk management costs for every manufacturer, every service provider, every retail store where we buy the things that we want and need. And businesses have no choice but to pass those costs along to us. And people will say, well, they can just reduce their profits. It's not as though, you have to remember that profit is a cost of doing business. And if I'm a business that demands more profit and my competitor demands less profit, my competitor is going to have an advantage because they can lower the price if I'm being greedy and demanding too much profit. Employers have to devote money and resources to risk management that they could otherwise spend on improving workplace conditions, improving efficiencies, and most obviously on wages and benefits to their employees. So perhaps the most obvious place that we see these rising costs in the real world are in housing costs. There is virtually no construction right now of entry-level townhomes or condos in Colorado, because if you build a townhome or condo development in that entry-level market, it is an absolute certainty that you're going to get sued. And there is this sort of construction litigation racket. And let me be clear, if you own a townhome or a condo or a home, a single-family home, and there is a construction defect, and the builder won't resolve it, justified in filing a lawsuit if that's the last resort. But this racket isn't the same thing. We had a piece of property, for example, in the Stapleton area, where there was the Central Park area, in any case, where a couple of the owners in our development did have some problems with their property. They went and consulted an attorney. The attorney will then often come to the HOA and say, well, if these two members of your HOA have this problem, the rest of you are going to soon realize the same types of problems. So why don't you let us represent all of you? And that way we can get it all solved at once and it will be more efficient. Now, sometimes the HOA will talk to its members and might be reluctant and say, why don't you just go ahead and represent these two people who have contacted you, and we'll let everybody else fend for themselves. Sometimes the more aggressive attorneys will actually threaten to sue the HOA for malfeasance for not representing all of their members. And at the point where the HOA board is faced with either being sued or simply signing on to the existing lawsuit, they quickly say, well, we'll sign on to the existing lawsuit. And here's what happens oftentimes. The people who actually had the problem will get their problem resolved, and maybe a few other people who hadn't seen the problem manifest, but it would soon, might get their problem solved. But everybody in that development is going to recognize some inconvenience and disruption while things are torn apart and the repairs are made. And if you're someone who had a non-existent problem, your non-existent problem gets fixed as well. And then when it's all said and done, there's a settlement reached between the plaintiff's attorney and the home builder or the contractor. And part of that settlement says that the home builder or contractor is no longer liable for anything that is covered in this settlement. So the plaintiff's attorney gets paid, the HOA gets something to pay for its expenses, and the home builder or contractor gets immunity from any future liability, which you would expect them to do once they've spent all this money fixing the problem. But if you're a homeowner who a couple years later has a similar defect that wasn't fixed or anticipated during this repair process and this settlement, if it was covered under the terms of the settlement, you now are out of luck because the home builder or the contractor has been given immunity from any future liability. The plaintiff's lawyer doesn't have any use for you because he has nothing to sue for. So now you and your insurance company have to fix your own problem. And that's kind of the way that this becomes a bit of a racket. The bottom line is that rising tort costs, whether it's for a small employer hardware store or whether it's for a larger contractor, make everything we buy more expensive.
Yep. Thank you for explaining that. And can you explain the issue around phantom damages and why that matters to businesses and consumers?
Sure. Phantom damages are a growing problem in Colorado, or sometimes if you look at insurance, it's referred to as billed versus paid. Anybody who has paid a medical bill knows that the amount on the original bill is not the amount that an insurer will pay to settle the bill, because providers routinely agree to accept payments that are substantially less than the initial bill. So when an injury leads to a lawsuit, like in the case of an automobile accident, the plaintiff is entitled to reimbursement for the reasonable value of medical expenses that were paid on his or her behalf. And the question that gets litigated in court is, what is the reasonable value that the plaintiff should recover? Now, courts in other states have said the reasonable value is the amount that the insurer actually paid to the doctor, the hospital, the provider. Other courts have said the reasonable value is something more than that actual amount, but certainly less than the original billed amount. In fact, even California's Supreme Court ruled that way. Mm-hmm. But Colorado's Supreme Court has ruled that under our law, a jury cannot even be told what the actual paid amount was. And instead, both sides, the insurance company and the plaintiff's lawyer, pay expensive expert witnesses to argue hypothetically about what is the value of the medical treatment while they all ignore the amount that was actually paid. And so the public policy question then is, should the plaintiff receive reimbursement that is equal to the amount actually paid, or should they recover the higher amount that they never paid, that was never owed, and that never actually changed hands? And we call the difference between the paid amount and the billed amount, we call this amount phantom damages, because they are damages that never really exist. And phantom damage cases in Colorado drive up the cost of insurance for doctors, for hospitals, for businesses, and for consumers. But they make litigation very profitable for personal injury lawyers.
Got it. Okay. Thank you for explaining that. We have just 6 minutes left, so I want to get some other questions in. We saw some bipartisan efforts at reform stall this year. We saw some good bills. We saw some bad bills. Maybe you could get into what some of those were in this legislative session.
The one that I think has the most potential this year is House Bill 1272. It's sponsored by one of the representatives in your area, Representative Shannon Byrd. It is attempting to deal with the home construction litigation problem. There are several other sponsors, but really Representative Byrd is the one that has taken the bull by the horns, researched this issue, and tried to find solutions. And what this bill does is it creates a voluntary liability protection and quality assurance program for home builders who want to build entry-level townhomes and condos. And if they voluntarily participate in this program, they are at the same time as they're building, they're having a neutral third party come in and inspect their work, again, for the purpose of quality insurance. And if they go through this process, then there are higher barriers in order to sue them. So there's an incentive to try to resolve the problem without litigation. I would say that is probably the most encouraging bill that's going through this year's legislature. There's been another bill that created some liability protections for property owners if they allow emergency services onto their property. That was a good bill. Been several bills that aren't so good. For example, there's been a series of bills in what I call the war on landlords, things to make it more difficult, more expensive for you to get deadbeat tenants out of your rentals. One would make it the ability of a tenant in an eviction process to request a jury trial. And all that does is slow down the eviction proceedings. And what frustrates me about this is I get why the proponents want somebody that they feel is simply a good tenant who's why they want them to have a few more tools. But those same tools can be used by tenants that aren't good tenants, ones that a landlord who's responsible wants to get out of their apartments so that the good tenants don't have to put up with them. And this bill equally applies that way. Another bad bill is House Bill 1239, which deals with ADA disability access lawsuits. This would allow for the first time under Colorado law for somebody to file an ADA accessibility lawsuit and immediately claim up to $50,000 in those non-economic damages that we talked about. So simply by virtue of the fact that somebody, a business owner, had a mirror or a toilet paper dispenser in the wrong place, they could ask for up to $50,000 in damages for per violation. So if you come in with a group of 6 people, have dinner, find 5 violations, you can multiply 6 people times 5 violations times $5,000 a piece, and suddenly you're suing for $150,000 for a violation that probably the business owner didn't even really know existed. So I guess I would give you the good and the bad side of what's going on in this legislature.
Yeah. And so that applies to existing businesses too, right? Not businesses that have, done their build out since ADA laws have come into effect. Exactly.
And what's often said is, well, you've had 35 years to learn how to comply, but you made a very good point. You've not had 35 years if you just opened a year ago, and when you got your certificate of occupancy, you assumed that meant that you'd met all of the relevant codes and regulations. And I will say this, there's been a separate bill. I'm sorry, if the question on the screen, if you asked it, my end was buffering, but do you want me to answer that?
All right, looks like we got cut off there for a sec, but we're back.
Sure, sorry about that.
Yeah, no, we're good. We do have a question from Brian Head. How did we get to this place in Colorado, and how should the business community better engage the legislature around the litigation climate in this state? It seems the plaintiff's bar has a powerful lobby.
They do. I mean, we're outnumbered about 6-1, and I wouldn't even want to know what the financial resources disparity is because it's a lot more than 6-1. But I will tell you this, probably the most powerful thing that can be that legislators can hear is when they hear a real live business owner, not an attorney, but a business owner that either they know from their district or that is just like somebody that they know who has experienced one of these lawsuits, and explain to them just the terribly frustrating process as well as expensive process that they've gone through, often to resolve a problem that if somebody had just handed them a letter or explained to them what the problem could have been resolved without litigation. So what can be done, I would say, is first of all, if you're in Chamber of Commerce, if you want to learn more about CCJL, any of these organizations, the most powerful thing you can do is to follow bills that create new lawsuits or that reform these types of lawsuits. And when one comes along that you can speak to, sign up to go testify in a legislative committee, because in those legislative committees, real people like us get to sit right across the table from the lawmakers who are making these decisions. And if they hear from somebody who's actually being affected, it means a lot more than hearing from a lawyer or a lobbyist.
Yeah, that's great. Thank you. Well, we're about at time, but is there anything else, any other call to action that you would like to get out there for people watching?
Well, let me mention our website, which is ccjl.org. There is a link on there where you can tell us your lawsuit story if you've been, unfortunately, in one of these lawsuits, that especially the ones that we would all agree are frivolous. You can also sign up for our newsletter, which doesn't come out all that often, but when there's new bills that are relevant. We can keep you up to date. And we always welcome new members. We have a wonderful mixture from small employers all the way to larger corporations, but in our organization, they all have an equal vote. And if we can bring people together who are truly the ones that can make an impact on legislators because they have a real story to tell, that's the most powerful weapon I think that we have.
Great. Well, thanks so much, Mark, for being on with us today. As I said, we'll get lots of rewatches on this, and you can post it anywhere that you would like to as well. And thanks for everybody who joined us. If you have any other questions, feel free to reach out to the chamber, and I can get those forwarded on as well. So we appreciate your time today, Mark.
Thank you.
Yeah, thanks so much, everybody. Have a good rest of your week.